4D Termination Incorporated, empowering non-custodial parents. The information contained in this video is provided for informational purposes only and should not be construed as legal advice on any subject matter. Friend of the Court and an Enemy of the Family, Part 2. How it all started. The video that started out as parental alienation and visitation then turned into child support payments, which has nothing to do with visitation. You can't be denied court-ordered visitation because of failure to make child support payments. The next video clip is going to show the video and where I confronted him. Here he is first speaking about parental alienation, and somehow that turns into how your child support payments fall into that. Now, what I had to do here was go ahead and tell the truth about child support services and how they are not a part of the state and how they do not play a part when it comes to trying to establish your visitation rights. So first I wanted to prove that by letting him know about the contract that is between the private company and the state of Oklahoma to administer and enforce these services. Here is where I was exposing the solicitation for the contract and the contract for private services itself, proving that child support services is not services of the state and that they are in fact private services. Here is that contract. Now, if you look at the top, you notice on supplier it says Systems and Methods Incorporated. Not only that, but these services are rented for 59 cents a year for a term of 7 years. 4D child support services are provided by a private company, and these are not state services. They are single and separate from the state, meaning they are a single and separate organizational unit that is operating in the Oklahoma Department of Human Services office. The Oklahoma Child Support Centralized Registry is also owned and operated by the private company. Your child support case is a loan that was taken out by the child support agency and signed in your name. They forged your signature to open up a loan in your name, and the reason why you have child support payments is so that you can repay back the loan that they took out in your name. On the IRS forms, they show you as the creditor and the child support agency as the borrower. How can you owe someone who is borrowing from you? If you want to check this for yourself, you need to go to treasurydirect.gov and put in your case number and the date your case was filed. Here is my child support bond. Here's my case number, and here is the date that my case was filed, and this is the interest, and here is the total bond value. Here is my paternity case from the online docket search for my state. This is my case number, and this is the date that my case was filed. Now that I've talked about the contract and I've talked about the loan, we're going to talk about what the debt is, and that is a lien that is against property that we don't own, which is the Social Security number. If you have a child support debt, the child support agency will put a lien against what is supposed to be your owned property. However, it is against the Social Security number, and we do not own our Social Security numbers. Take a look at the back of your Social Security card, and that clearly proves that. Here, this is where I had to let him know that he was not doing a good duty to the community by reminding non-custodial parents to pay their child support payments if they're going through parental alienation and visitation issues, when, as a matter of fact, child support doesn't play no part in any of those issues. This is only a reminder for non-custodial parents to pay them to represent them so that they can screw them in court and be paid again for screwing them when they were supposed to be representing them in the first place. So I had to remind him that financial support was not the only type of support that a child should need from their father. What about the emotional and mental and physical support that's supposed to come from a parent? So I had to explain to him that the fraud and corruption that comes from these private services comes from the states who administer and enforce them. By him promoting these services as state services, he is part of the problem. Now we're going to take a look at his response to my comments. Instead of simply just replying to my comments, he made a whole video. This is Brian Jackson with the James Worth Law Office.
Hello, my name is Brian L. Jackson, and I am a Tulsa Fathers Rights Attorney. And today I'd like to talk a little bit about what happens if you don't pay your child support. Recently, guys, I've seen a lot of comments on the Tulsa Fathers Rights Support Group that which I'm a member of, about whether or not you should pay child support, and even going as far as to say that it's a scam. Political feelings about child support aside, and whether or not it's a good policy, because I think that's a separate discussion and it's sort of beyond the scope of what I'm trying to do here. Child support is the law, and it's pretty unambiguous. If you have a child support order out against you, it is not an optional thing. You must pay. And if you don't pay, you're defying a court order, that is in fact a crime. It's also civilly actionable as contempt of court. And if you incur a high enough debt, then it can also potentially constitute a felony failure to pay child support. So what happens to you if you don't pay? Well, first thing that's probably going to happen to you is if you have a DHS case open, DHS will begin to take collection action against you. One of the things they like to do is they'll reduce arrearages to a judgment and do what's called an in personam lien against you, which basically means they're going to file that judgment with the county clerk in the county where you live, and that judgment then becomes a lien against all your property. You want to sell your house, you got to pay your child support first. You want to sell, you want to sell any other personal property, that lien can attach, and you may have to pay your child support out of the proceeds. They can take your tax return if you owe child support. If you get any other money like that, they can take it. You get a judgment in civil court, they can put a lien against that. They can garnish your wages. Then it gets worse from there. In Tulsa County, you have a docket here that deals especially with people who are cited for delinquent child support, and it's called the Rocket Docket, and there's a reason for that. One of the consequences for not paying child support is that your child's mother, ex-spouse, however you were related to her, and or the Department of Human Services can file a citation for contempt against you for violating a child support order. And civil contempt can carry both fines and jail time in addition to what you may already owe in child support. And it's up to 6 months in the county jail. And I don't think I need to tell you, jail sucks. So, and the Rocket Docket got its nickname because they move those cases real quick. You know, you can go from being cited to being on trial to being tossed in jail pretty within a few months. And the judges on that docket routinely put delinquent fathers in jail for non-payment, even if the mother says, "Don't jail him, I want the money." So it's a big deal, and it carries serious consequences. And you do not want that to be you. Now, if you do find yourself in a situation where you cannot pay, either because you've lost your job or some other exigent circumstances have occurred, the first thing you want to do is hire a good lawyer. And ask them about filing a motion to modify child support. There is a procedure for that. There's a correct way to handle that situation. It is not allowing a massive delinquency. If you do that, you're going to get jammed up. And I can tell you from personal experience and knowledge, as someone who practices in this area regularly, child support delinquency is really taken seriously, and it can really hurt you. And they come out, the state's attorneys through the Department of Human Services and private attorneys and judges come at this very aggressively, and they will come after you. And something else to be aware of as well: if you are involved in custody litigation, or you're dealing with a situation where your child's mother is not letting you see the child, we talked earlier about parental alienation. Owing child support will not help you, especially if you're trying to convince a court to give you custody, because the court's liable to look at it from the standpoint of, you don't care enough to pay to support your child, and now you're asking me to give you custody. The court's going to look at it as, obviously you only want custody so you can get out of paying. So again, don't do that. I can understand the temptation not to pay if it seems like it's excessive, or worse, if you're dealing with a situation where she's not letting you see the kids. You have remedies to deal with not with refusal of visitation, in the form of contempt of court citations and in the form of a motion to enforce. Withholding child support is not a legal remedy to that, and it will get you jammed up, and it may make it harder later for you to convince a judge that they need to come down on your ex-wife or your baby mama if you owe money. So don't let that be you. My name is Brian L. Jackson, and we've been talking about what happens if you do not pay your child support. If you find yourself in a situation where you can't pay, or where you're being denied visitation and you don't think you should have to pay, call me. I'll help you out. Don't take matters into your own hands and stop paying. And don't let your ability to not pay result in a massive delinquency. It's not going to help you. Again, my name is Brian L. Jackson. I'm a Tulsa Father's Rights Attorney, and it's been a pleasure, guys.
So, of course, you know I had to respond to this video. First things first, I had to let him know that it was not positive law. Second is that the Supreme Court ruled that child support was created to benefit the secretary and not the child. And again, I had to let him know that they are a single and separate unit, meaning single and separate from the state. Here again, I am talking about the contract, except this time we're going to talk more about System and Methods Incorporated and exactly who they are and why they play a part in our child support services that are being administered and enforced in our state of Oklahoma. Child support services constitutes 92% of their revenue. They provide our child support services and the payment processing for our child support payments. Their website clearly states that they are a private company. They have been privately contracted to supply the state of Oklahoma with their private child support services and child support payment processing since 2012. 9 district attorneys are contracted with the Oklahoma Department of Human Services to help administer and enforce these private services. They too are signed into this private contract, which makes them private subcontractors. While they are administering and enforcing these services, they do not have the judicial authority to charge you with contempt and incarcerate you because they are now private employees of the private company who is supplying the state with these private services. So, by acting as the state when they are offering or administering and enforcing these services, they are acting under color of law. Remember, they are private employees while they are handling these private services. They are no longer employees of the state while handling these Title 40 child support matters. The Oklahoma Child Support Centralized Registry is not a service that is of the state. It is a private debt collection agency. And again, here I am explaining to him how the child support case is actually a loan that is taken out in my name. And I'm also showing him again about how to go and find that. Moving right along, I go in and I explain about how it is a voluntary agreement that establishes the administrative order. Without this voluntary agreement, there can be no established child support order against you. By acting as the state when they are offering you these private services and telling you that this voluntary agreement is mandatory because it is a court order, they are acting under color of law and forcing you to sign a voluntary agreement by coercion and under duress. So we're going to take a look at 31 USC subsection 3720D. And we're going to look at the bottom. And at the bottom, clearly, it states that there is an agreement between you and the child support agency director. So what's the legal definition of an agreement? An agreement is a contract. This contract is also supposed to be offered to you as voluntary. So in order for that contract to be valid and to be legally enforced, it has to be established using the 5 elements of a valid contract, expressed by a valid offer and acceptance. The offer wasn't valid because we were not told these are private services. The acceptance can't be valid because we were lied to. They have to tell us everything and disclose the full terms and conditions of what will happen in a child support case, the good, the bad, and the ugly. They also have to tell us that they are not of the state and that they are private services and that this is a voluntary agreement. That is the example of a valid acceptance and offer. So how many of you were told these things? We wasn't. And it was a violation of our 5th and 14th Amendment right to procedural due process. So let's also talk about the fact that all child support 4D matters are civil matters. You cannot hold one in contempt for a civil matter. Contempt charges are for criminal proceedings. And in order for there to be a civil matter, there needs to be an injured party who can take the stand and point you out in court and let the court know that you did to cause harm on them. The state is not a person, and the state cannot be an injured party. It's a conflict of interest for the state because the prosecutors work for the state, and the judge is the state. Now I wanted to catch him up real good. He said that if you were found delinquent, that you would be charged contempt and held in jail for 6 months. That is totally against the federal guidelines, and the Department of Justice sent out the Dear Colleague letter on March 14, 2016, informing these child support agencies not to do those things if we are found willing to pay, but we are unable to. When I showed him this letter, he told me that that letter did not apply to 4D agencies, when clearly in the letterhead it was supposed to be made out to every 4D agency in the nation. 4D child support is a cash cow for our judicial officials and the government. It plays no interest for the child or for the custodial parent, and they don't care about our family hardships that are going on behind it. As long as they keep enforcing, they're going to get paid. As long as we keep making payments, they're going to get paid. So it's not about supporting the child, it's about putting money into the pockets of these people. You can't discuss the issue of parental alienation and support it with child support. Child support is the problem to parental alienation because it creates a false sense of bureaucracy for the custodial parent. This false sense of bureaucracy is harmful in establishing the relationship with the non-custodial parent and the child. How can that be in the best interest of the child? Because it has nothing to do with the child. It is a money laundering, racketeering, and extortion that comes from the states by abusing the federal guidelines. They don't care about the other types of support that a child needs. Their only concern is the financial support because it puts money into their pockets. So here is both James Worth and Brian Jackson with the Worth Law Office responding to my comments on Brian Jackson's video. So if the decision of contempt and the decision of if the inability to pay was willful or not is up to the judge, don't you think the judge is going to do the contempt because this is what he's getting paid for? But again, the judge is under the private contract, and they are considered as private employees by signing into this private contract. But again, he's missing the fundamental point of the voluntary contract that establishes the administrative order and not the judicial order. So here, this is where I'm trying to explain to him that the agreement was not valid to even establish the administrative order in the first place. But instead, he would rather go on about how it is a court order and a responsibility to pay the child support payments. The judges don't care if you show the inability to pay. They are still going to give you a contempt charge and sentence you to 6 months because that's what they did to me. It's all about putting money back into their pockets. How was sending me to jail for 6 months the best interest of my son? So here is where I want him to show me legal citation where I'm wrong about these claims, rather than just telling me that it is a court order and it's mandatory by the state law. But rather than doing that, he would rather go on with hearsay. Clearly it's a contract because I just proved that. So again, I give him 31 USC subsection 3720D, which clearly states that there is an agreement between me and the child support agency, just as any other non-custodial parent with a 4D child support case. Here again, we are giving him legal definitions of an agreement, which is a contract. Without this binding agreement, there is no contract. So again, here I am explaining two of the most important elements of five of a valid contract that are missing when it comes to the voluntary agreement for child support services, and how they are acting under color of law by acting as the state and telling you that this is mandatory by court order. So here I'm showing him my paternity order and child support obligation. Notice how it's an order for paternity, but it's an obligation for child support. So again, I hit him with the legal term of an obligation, which turns out to be a contract. Child support is a civil matter which falls into private law. Moving along, I go to explain how these services are supplied by a private company to the state of Oklahoma and that these are not state services. Here is the contract once again. This is the private contract between the private company and the state of Oklahoma. Child support services is a private contract. These services are not forever. They only rent them for a certain amount of time, and then once their term is up, then they have to reapply and rent these services again, or they can move on to another private company who supplies these services. These services don't belong to the state. Later on that night, I get a direct message on Facebook Messenger from James Worth. So again, instead of trying to prove me wrong in my claims, he still wants to know where on his website that he's advertising for 4D services. He doesn't want to talk about the truth behind the corruption, but rather more about his reputation. So I let him know where my video came from, and it was from Brian Jackson trying to rebuke me from telling the truth and exposing the corruption from family lawyers. And I was also letting him know that my claims are not in reference to private child support matters and that these are for Title 4D child support cases. However, private attorneys are part of the 4D corruption as well. Whenever you are representing someone with a 4D child support case, you are also getting paid the incentives as well as the judges, the district attorneys, the sheriffs, and the court clerks. When he said we have many child support cases, that was his way of telling me, yes, I have 4D child support clients. If you represent someone with a 4D child support case, you have everything to do with the 4D contract. So I asked him, do you want me to show you the U.S. regulation and Code of Federal Relations that state this for the fourth or fifth time already? Here he is clearly pointing out that a public defender is appointed in criminal cases. contempt where the defendant cannot afford an attorney. So why am I given a court-appointed attorney when I'm charged with contempt for a child support matter, which is a civil matter? Remember, this is an administrative order. So where is the authority to hold me in contempt for a civil matter coming from an administrative order? He wanted to know where the funding was coming from, so I let him know that they are paid by grants and by incentive payments. They are matched for every dollar that is paid into child support by non-custodials for their child support payments. It's all about putting money into the pockets of these people. It does not have anything to do with the best interest of the child. These grants and incentives come annually. Support collected by one state on behalf of individuals receiving 4D services in another state shall be treated as collected in full by each state. It's all about lining their pockets up with our money. We are basically paying them to screw us. The Federal Office of Child Support Enforcement will estimate the total incentive payment that each state will receive annually. States only have to pay a quarter of what they pull in from child support payments to the federal government. And again, he's trying to put it off on DHS, child support, and DA offices, and that those things and problems do not have anything to do with him. You can't trust these guys because they're not going to tell you the truth because they are involved in the truth. They are part of the problem. And if you get off of child support and you don't pay them to represent you and they can't enforce any child support payments from you, then they're not lining their pockets anymore. Why would a 4D case not be a 4D case whenever that 4D case becomes a contempt charge? And if I was appointed court counsel because of a 4D matter, then that private attorney who was appointed to me has everything to do with the 4D contract, or he wouldn't be there in the first place. So again, for the third time, here I am showing him the private contract between the private supplier of our child support services and the state of Oklahoma. Again, this is the third time I've shown this to him. He has never heard of SMI until I created the part 1 video of this video, which I posted in their Oklahoma Fathers Rising group. How can you have clients with 4D cases and represent them and know nothing of the private company that supplies the services? So again, for the third time as well, I have to tell him that the child support agency is a single and separate organizational unit. And I also have to explain to him that the child support agency in the Oklahoma Department of Human Services belongs to Systems and Methods Incorporated. It doesn't belong to the state. It's a single and separate organizational unit that is operating in the state agency. He's not even comprehending the citation that I gave him. It clearly states that the 4D agency is located in any other agency of the state, meaning that the 4D agency, aka the child support agency, is not DHS. And of course they represent the state. But see, as a private attorney who is representing someone with a Title 4D case, you also represent the state. And so here is where I clearly explain that to him. It doesn't matter if you're a private attorney or a court appointed. If you are representing a client with a Title 4D case, then you are also under this contract and you are part of the problem. This is not true. Whenever the custodial parent signs the cooperation agreement for child support services, they are signing over their rights to the state to act on their behalf. So no, the custodial party is not part of the court proceeding whenever you are in court for a contempt charge. My son's mother has never been in the courtroom for my child support hearings because it's always me versus the prosecutor. My court appointed counsel was most definitely a private attorney. So by this point, he stopped responding to me, and I just kept sending him messages that were showing facts to my claim. And I have not received a response from him yet. But I'm going to continue to let the video of the messages to play through so you can see the whole conversation. So just so we're clear on this, your child support order is actually a child support obligation. That child support obligation is a contract, and the foundation to that contract is a voluntary agreement. Without that voluntary agreement, there can be no contract. And without that contract, they cannot establish the administrative order. Without the administrative order, there is no legal enforceability for child support. See here, an obligation is a binding agreement to a contract. So obligation is another word for agreement. Your obligation requires a voluntary agreement and a commitment. But that agreement and that commitment must come by free will and consent by you without duress. So if their offer was they are the state and these are state services and you accepted that, then it was not a valid offer because they are not state services. So even though I'm giving him legal terms and definitions, he's telling me that these legal terms and definitions have no authority. Well, of course they don't have authority, but they are considered when it comes to court terms and court definitions. And yes, Black's Law is used in courtrooms widely across the nation. So this is him again trying to prove that he's not the problem, when in fact he is, because he's giving false information here. The individual can't be the custodial parent because they signed over their rights to the state to act on their behalf. So here is Black's Law Dictionary definition of an obligation, which is a contract. Throughout this whole video, I think I've showed this private attorney about 7 or 8 times how this is a contract, and he is still sitting here trying to mislead me and give me false information to prove how it is a mandatory court order by the state of Oklahoma and how it is not a voluntary agreement. So we're going to look at the word legally bound that he sent me. So I asked him, so I'm legally bound? He told me yes, based on a court order. Cool. Now let's look up the legal term of legally binding. The term legally binding refers to the requirement that both parties involved in the contract must obey the terms detailed in the contract. Okay, so here we are again with a term that you gave me to use, and it specifically explains how it is a contract once again. Now his argument is phrases can have more than one meaning, and that I'm wasting my time and potentially missing out on viable legal avenues. I'm pretty sure my skills are pretty okay when it comes to reading and understanding what I'm reading. And from what I'm reading from this citations, this is all a contract. So now I'm just going to show him in the federal child support handbook where it says that non-custodial parents are to enter into agreements for child support orders to be established. Not only that, but I'm going to show him the federal child support glossary of terms and definitions, and we're going to look at the word agreement and how that definition explains that it is a voluntary agreement to enter into the child support responsibility. It all starts with the voluntary agreement. He has not once sent me a legal citation to tell me where I'm wrong, but yet he wants to tell me that I should listen to him because he's trained in that area. Right. So I'm just going to lay this page down from the Child Support Handbook. And I'm going to lay this agreement term and definition down from the Child Support Glossary of Terms and Definitions. And just to throw a little extra spice on it, I'm going to give him some more reference of how a 4D child support case is established. And it starts with a voluntary agreement. This is it. There's nothing that he can do to prove this to be wrong. 4D child support cases, or court orders as they try to tell you, start with a voluntary agreement. You have to voluntarily agree to the services. The purpose of this video and part 1 is to simply prove that you cannot run to a family attorney to help you with your child support matter, because they're not going to help you. They're just going to tell you how to potentially put a band-aid on it. Take some time to study and learn about this corruption so that you can learn how to represent yourself. Created and edited and produced by me. Thank you for watching. And if you like what you saw, then hit the subscribe button so you can learn more.